I want to discuss about the method of conducting the case management conference. It is especially a desirable subject during the COVID-19 pandemic time. It is widely accepted nowadays that the initial procedure meeting, not just the initial procedure meeting, but perhaps the hearing, could be conducted virtually. An initial procedure meeting could last from 1 hour to 3 or even 4 hours, depending on the complexity of the matters discussed and also depending on how the presiding arbitrator managed the meeting. It is often considered good practice for the participants to, while talking, mute their speakers, and so that everyone can hear the speaking person clearly without any background noise.
The limitations to party autonomy. I'm starting with the English position, and I mentioned earlier that I will come on to the English position. The English position actually represents a good example of how there are limitations to party autonomy and what they are. So the first thing you see in the general principles in Part 1 of the English Arbitration Act of 1996, and you'll see that the arbitration legislation of England goes back a long way, but in fact hasn't been modified in that long, and actually still does a very good job by way of a frame of reference of what is a good legislation. So what does Principle B say? It says, and I'm reading from the slide, the parties should be free to agree how their disputes are resolved, subject only to such safeguards as are necessary in the public interest. So there you go, there's a limitation to party autonomy.
The grounds for refusal of recognition or enforcement of interim measure in Article 17I follow the grounds in the New York Convention, that is, invalidity of the arbitration agreement, a party was not given due notice, the decision falls outside the arbitration agreement, composition of the tribunal was not in accordance with the parties' agreement, or in the absence of agreement, the law proceed. The dispute is not arbitrable or is contrary to the public policy of the state. But it adds 3 additional grounds specific to interim measures. These are: the tribunal's decision on the provision of security in connection with the interim measure has not been complied with, the interim measure has been terminated or suspended by the tribunal, or was so empowered by the court of the state in which the arbitration takes place, or under the law of which that interim measure was granted. The interim measure is incompatible with the powers conferred upon the court, unless the court decides to reformulate the interim measure to the extent necessary to adapt it to its own powers and procedures for the purposes of enforcing that interim measure and without modifying its substance.